we might as well strap these notes onto carrier pigeons and send them as well. With that, we will move to the gentleman from the Commonwealth of Virginia. Mr. Beyer, you're now recognized.
Mr. Chairman, thank you very much. And thank you and to the ranking member for holding this. As all the members of Congress here, lots and lots of negative feedback on our constituent service. It's a really consistent thing, and I share our frustration. I'm a huge fan of process management. Rather than just throwing money at things, taking the pieces apart and trying to look at each section of it. So an obvious question, and not to be repetitive, but I'd love to get the answer. As best you can, Ms. Cara Davis, why haven't we eliminated reconsideration? We have 20-year projects. All the groups think it's the right thing to do. Why do we cling to it?
So we did test it, as someone on the panel mentioned here. There are thousands of people who receive benefits are allowed at the reconsideration level. It's actually streamlines the process. It's costs less money to process a claim at the reconsideration level, but certainly if that's something you're interested in exploring, we're happy to work with you on the technical aspects of that.
Are you aware of any legislative attempt at the congressional level to eliminate reconsideration?
No, I'm not currently.
Okay. Ms. Burdick, it's the same line of thought on process management. The treating physician rule. Again, I'd love to know, why did they get away from that? Is there a sense that you can't trust the physicians that are treating these people because they're their friends and they're from their communities? Or is there a really valid reason why the treating physician rule shouldn't be in place?
The task force would endorse restoring the treating physician role. And I will say, when they eliminated it, none of the reasons that were put forth we found were very compelling. I mean, because when it comes down to it, there doesn't seem to be any reason why you wouldn't try first and foremost to get the treating provider to weigh in on a person's claim.
They're the ones who know them best.
They do. And without that, there's this reliance on Social Security consultative examinations, which are there for a reason, but this is a one-time doctor, usually doesn't have any of the specialties of the person who's talking to them. It just isn't, the evidence created isn't as persuasive. It takes time, it costs money, and it would just be so much more efficient to go to the source in every case.
Thank you. Mr. Camp, Dr. Warshawski suggested that because the attorneys get paid on the total amount due, there's an incentive to postpone it as long as possible. How do you react to that as an attorney representing these folks?
It isn't our real world. We get hired to obtain the appropriate outcome, but as fast as possible. Every client that retains an attorney is expecting us to make the agency perform better services, to go faster primarily. We're the ones on the phone with the clients every day. We're the ones that are frustrated in being blocked and speeding up the cases. It is our job to make the claim go faster. And that would be an unacceptable failure to serve your client, which is not something professionals do if they expect to last.
Thank you. Dr. Warshawski, to roll up, let me quote you: "The currently needlessly complex and outdated rules that both claimants and agency use to determine eligibility for disability benefits have to be simplified, modernized, and automated." Is there anyone charged with doing this? Who owns that charge?
When I was at Social Security, I was in charge, and the regulation was written. In fact, it was ready to go literally days before the change of administration. So it's there. And it was an agency-wide, in fact, even a government-wide effort. So it involved people from the Office of Management and Budget. They were extensively involved. The entire agency, people in operations, people in the actuary's office, people in the hearings office, the budget office. It was a total agency effort. My very rough estimate is that it cost $100 million in terms of people time to do that, in addition to the expenditure of $300 million for the data. And it stopped. It's sort of inexplicable.
And what would the savings be if implemented?
Well, I can't speak to that in terms of it would definitely speed things up because it would be automated, and it would be relying on current data, so that would provide much more accuracy at the initial level in the claims. I think it would be a vast improvement.
Thank you. Mr. Chairman, I yield back just with the question that, once again, there may be a window for legislative initiative here, too.
I thank the gentleman, wholeheartedly agree with you. I'm going to ask for unanimous consent to enter into the record the fiscal year 2022 disability decision data. This came from SSA's budget document. The ranking member and I have been looking at this.